Yes. Yes, good morning. Again, we understand the temperature is on the cool side. Please let me know if anybody's inconvenienced. Thank you. Yes, Mr. Cox, where do we go next?
Well, my Lord, I want to make two short points under ground one before turning to ground two. The first is to correct a response that I gave yesterday to a question from my Lady Justice Falk about the appeal right that arises based where a restriction is imposed based on pre-implementation period conduct. I said that appeal right arose under the regulations with which the court is concerned in this appeal. That wasn't right. Having looked at it in detail, I accept that I say, and I think it's a common ground, that the appeal right arises under the Immigration European Economic Area regulations as continued and as modified by the citizens' rights, open brackets, restrictions on rights of entry and residence, close brackets, open brackets, EU exit, close brackets, regulations.
These are the 2016 regulations?
These are the 2016 regulations as modified by the Withdrawal Agreement regime.
Right.
But I say the point I made remains a good one, because the sole permitted ground of appeal conferred by those regulations is that the decision breaches the appellant's rights under the Withdrawal Agreement. It's essentially the same grounds as those permitted in this case. And the decision that gives rise to the right of appeal is made at the same moment and empowers the making of a deportation order. It is not itself a deportation order.
So in the Secretary of State's terminology, it's a stage one decision?
I'm not going to use that because stage one decision has been used to mean many very different contradictory things, but it is, in common parlance from the Secretary of State's officers, a decision to make a deportation order. That is how it is referred to in the documentation. Technically, it is a decision to remove the person under Regulation 23, but it is not a deportation order and it does not itself execute any restriction on rights. And therefore I say if the Secretary of State is right, that ground of appeal is also incapable of succeeding in those cases, as she says it is here. And it is only if we are right, and my submissions to you yesterday, that a decision to deport is a decision restricting rights for the purposes of Article 21, does the appeal have content? The second point in relation to ground one is to address the amendment regulations that were adopted while this was while this appeal was in progress. And I do that because they're before the court and they've been mentioned as relevant, though strictly speaking they don't apply to these cases. They are at page 196 of the authorities bundle. I could ask the bench to turn those up. So the operative regulation is Regulation 2, and it inserts a new paragraph in the regulations that applied in these cases. 1A, for the purposes of paragraph 1 only, a decision to make a deportation order means a decision to pursue deportation that is made after a person has been asked to make representations to the Secretary of State as to why they should not be deported. And the rationale for that amendment is over the page at 198 in the explanatory note. And it says in 4 lines down, this is to ensure that the 2020 regulations appeal right aligns with the point a right of appeal arises under Section 82 of the Nationality Immigration Asylum Act 2020, which provides a right of appeal in respect of a refusal of protection and or a human rights claim. This means that when a decision to make a deportation order is made, the right of appeal under the 2020 regulations will now arise after the person has been given an opportunity to make representations and the Secretary of State has decided to pursue deportation. And if a separate right of appeal arises, both appeals can be considered concurrently by the tribunal. Now, in my submission, this would only operate to confer a meaningful right of appeal if the tribunal in Vargova and the Secretary of State here are wrong on issue 1. Because the legal effect...
Just a moment. Only give a valid right of appeal if the tribunal in KV and the Secretary of State...
Do you mean the upper tribunal?
I do, sorry.
Sorry, I wrote upper tribunal but said tribunal. The upper tribunal and the Secretary of State were wrong about ground 1.
Yes. And that's because the legal effect of a decision to deport is the same whether it's made before or after representations are sought. It's still only a decision to deport. It still requires the further step of a deportation order for the restriction on rights to be executed. It only works if the submissions made from this side of the room are correct. That a decision to deport is a decision to make a restriction under Article 21 of the Withdrawal Agreement. So the scheme remains unworkable on the Secretary of State's case and only workable on ours, notwithstanding the amendment. Turning then, if I may, to ground 2, proportionality.
Yes.
The Court already has my submission that Article 20 of the Withdrawal Agreement, the reference to conduct means conduct of the individual whose rights are to be restricted. Without turning it up for the moment, I would respectfully remind the Court that Article 21 refers to safeguards, not procedural safeguards. We endorse the submissions made earlier that proportionality is a fundamental principle of European Union law, and since the right of residence that is being restricted arises under Article 13 or 15 of the Withdrawal Agreement, which are continuations of the European Union right to reside under Article 21 of the Treaty, CAT, proportionality must be satisfied by a state party seeking to restrict those rights. Like the other parties, we accept that the limitation on permissible grounds imposed by Citizens' Directive are not applicable in Article 22 cases. Proportionality is not a limitation on the permissible grounds. It is a limitation as to whether the grounds for a restriction justify that restriction in a particular case. It is a safeguard. As regards the textual approach to the Citizens' Directive, we, like the IMA, would urge caution in terms of the Court giving a ruling as to which of the guarantees may apply. So, for example, guarantees such as those as to whether the appeal should be in country or out of country in Article 31(2 may not necessarily fall for decision, but we accept, of course, that the interpretation of the directive may depend upon understanding all of its text. We would adopt the argument that Article 31(3 affirms proportionality, including the requirements of Article 28(1 in deportation cases. I don't think it's been argued that Article 28(1 only applies where public policy grounds are advanced. We say that wouldn't fit with the abolition of the limitation on grounds, but anyway, can't be right, because then the guarantees would be fewer where the ground is weaker, as not on grounds of public policy. But we do maintain, and if I could, I don't think I need to ask the Court to turn it up, we do maintain that one of the guarantees is that in Article 27(2), first sentence, that when considering the conduct said to justify the restriction, the decision maker is restricted to the personal conduct of the individual concerned. And we say that is affirmed by the reference in Article 20, paragraph 2, to conduct. what does proportionality require here? I'd asked the court to look, and I won't repeat it, given the limited time available, at the submissions made in our skeleton, paragraphs 81 to 84, which is pages 53 to 54 of the Molnar core bundle. But what we say that the domestic cases show, as do the cases from the Court of Justice, is that proportionality under European Union law is quite different from Article 8 proportionality in the UK. Most obviously, the detailed statutory regime that Parliament has adopted in what is now Part 5A of the 2002 Act
Doesn't apply.
Sorry?
Doesn't apply.
It couldn't have applied under EU law.
Yeah.
But that is not only because of the limitation on grounds, that is also because of the requirement to give great weight to the right of residence in the EU, in the UK, which we say is the continuation of what is expressed in those cases as a right of free movement. Obviously, the right of free movement has been restricted for a client like myself, my own client. He enjoys it within the rest of the EU, but he does enjoy the right of free movement between the UK and the EU. He can come and go. That is the right conferred by Article 14 of the Withdrawal Agreement. And he can, subject to these restrictions, stay here for as long as he wishes. And so his right in that sense is the same as it was under the EU. Turning then very quickly, if I may, to the first tier tribunal decision in my case and the grounds of appeal. And I just want to do this to emphasise the limited nature of the rulings below. If I could ask you to turn up page 129 of the core bundle. This is the decision of First Tier Tribunal Judge Swaney. And we say there is no material error of law in this decision, and that the court should reverse the upper tribunal's ruling to that effect. Paragraph 1 records that there were, in this case, unlike Ms. Vargova's, two decisions, a decision to deport and a decision to refuse human rights claim. If we turn to page 134, at the bottom, we see that the judge heard a detailed argument on which of the protections in the withdrawal agreement applied to the appellant. In this case, though don't take it as a pleading point, the Secretary of State accepted that the Article 20, subparagraph 2 applied. That's paragraph 36. No point was taken that the decision was not a restriction. And if we turn then at the end of the argument to paragraph 48 at page 138, in the second sentence there, the judge rejected the argument being advanced by the appellant that 27 and 28 in their full effect applied to him. But what she does say, adopting essentially the position that's been advanced in this case, page 139, top, the requirement that the decision comply with the principle of proportionality does not amount to a substantive safeguard, using the terminology there. It's not terminology that I would adopt, but to which the appellant is not otherwise entitled. Finding the respondent's decision does not comply with the principle of proportionality does not result in the appellant establishing a right not to be deported. Nothing to prevent the respondent from making a new decision to deport the appellant which does comply with the principle of proportionality. She was doing that because, as we saw earlier, the decision in this case did not address proportionality at all. And so then in 49 she concluded that that the respondent ought to have applied what she calls procedural safeguards, in particular ought to have considered proportionality. And on that basis, at the end of, he ought to have done that, she ought to have done that. The paragraph 51 concludes on the evidence that she hadn't. The Secretary of State's appeal grounds are set out at page 126. sorry, well, in fact, 125, paragraph 9, the essence there is that no proportionality criterion exists in Article 20, paragraph 2, and no proportionality decision is required. That's essentially the single ground, and we see over at page at paragraph 14 that the Secretary of State invited the Upper Tribunal to set aside and refer the appeal to a different judge, which is what the Tribunal then did. There was no appeal against the decision that if EU law proportionality applies, it had not been satisfied. And there was no appeal from the holding that the human rights assessment of the appellant's case did not meet the requirements of EU law proportionality. Limited time, so I won't take you to it, but you can see the Upper Tribunal's conclusion at page 121. They essentially accepted the Secretary of State's case, adding in the point that it wasn't a restriction, and they remitted the appeal to the first-tier tribunal. Secretary of State Skeleton has floated the possibility that that order could be altered if we lose. So paragraph, page 71. We say that's impermissible. She didn't appeal that order.
Sorry, just say that again.
She floats the possibility that if we lose, Mr. Molnar loses, that this court could nevertheless vary the order of the Upper Tribunal below so as not to remit the appeal under the 2020 regulations. We say that that's not the subject of any appeal from the Upper Tribunal. And indeed, that was the order she sought before the Upper Tribunal, and therefore there's no basis on which the court could vary that order of the Upper Tribunal if we lose, and therefore I don't propose to address you on the substance of why the court shouldn't do that.
Isn't this court able to take any course that the Upper Tribunal could have taken?
In my submission, not if you dismiss the appeal. You'd have to be allowing somebody else's appeal against something the Upper Tribunal did, not mine.
Good point, Mr. Cox.
Well, unless there's anything else that I can help you with.
No. Okay, thank you very much, Mr. Cox. Yes, now, Mrs. Smythe. I hope you've got enough time.
Thank you.
There'll have to be an opportunity for them to reply.
Yes, of course. Just give me 1 moment to organise myself. So, my lord, my ladies, I'm proposing to just summarise our response, then to address 5 broad topics and make submissions as I go, and then finally what I'll call mop-up points. The court will have 2 skeleton arguments from us, what we've called our lead skeleton.
Yes, in the Vargova,
Yes, that's right, and then the Molnar skeleton.
is a
Paragraph 6 to 9 of our main skeleton summarise our overarching response, so the court has that in writing.
Would you like us to have that open in front of us?
It would be helpful to have the skeleton if that's okay. I don't need the court to read 6 to 9, but just to be aware that's where we summarise our position.
Well, we've looked at it in the course of the...
So if I can perhaps just headline our response and make 3 points. The first is that we say Article 20 sub 2 of the Withdrawal Agreement is clear that if an EU citizen commits criminality after the end of the transition period, they are subject to national law. They don't enjoy the protections of Chapter 6. That's our headline submission. The second fundamental point is that having done that, we say in clear terms, Article 21 does not bring those protections back into play. And third, we say that the argument that's now advanced in this court about grounds versus safeguards simply does not stand up to scrutiny, and I'll explain why. And we say that the reason that the parties are scrabbling around to come up with ways to try and make their arguments work is because they're trying to give Article 20 sub 2 some effect. But it doesn't work for the reasons that I'll explain. So those are our headline submissions. The 5 broad topics I'm going to cover are as follows. First of all, I will deal with domestic deportation legislation and how the decision-making process works. Then I'll follow that by dealing with appeal rights. Then I'm going to touch on what the EU proportionality principle actually is at its core. Fourth, I'm going to look at the protections in the directive and the application of the proportionality principle in that context. And then finally, I'll deal with the withdrawal agreement. So, starting then with the first topic, which is domestic deportation legislation, could I just ask the court to turn to the first authorities bundle, tab 2, and the 1971 Act. Now, what we say is this idea of a stage 1 and stage 2 decision is not something that the Secretary of State has grafted onto the legislation. It comes from the legislation. So although the names don't come from the legislation, the distinction between the two does. So the first provision is section 3.5 on page 7. And that says that a person who's not a British citizen is liable to deportation if, and the first limb is the one we're interested in, the Secretary of State deems his deportation to be conducive to the public good. So the Secretary of State calls that stage 1. That's the point at which the Secretary of State decides, I think your deportation is conducive to the public good. Now, except in a 2007 Act case, she doesn't go through that thinking process, but this is the fundamental legislative structure. You have a stage of deeming deportation to be conducive to the public good. And then there are various exemptions for relevant persons which we say are inapplicable here. And then section 5.1, which is on page 16, this is the second stage. Where a person is under section 3.5 or 6 liable to deportation, and in the section 3.5 case that will be because the Secretary of State has decided that their deportation is conducive to the public good, the Secretary of State may make a deportation order against him. So that's the second stage. The Secretary of State then has a discretion as to whether or not to make a deportation order. So that two-stage process is baked into the primary act, which is the 1971 Act. Just to touch on the detention provisions, in Schedule 3, the court will see page 35. The numbers are very small, so I may be bending up and down. Page 35 is removal of persons liable to deportation, but the court can see there that paragraph 1.1 on page 35 is where a deportation order is in force. So that is after stage 2. Just in passing, could I invite the court to note that under the 1971 Act, paragraph 2.1, where the court recommends deportation, the person shall be detained unless an exception applies. So actually, contrary to what was said yesterday, and I'll go to the Bouchereau case in detail, it's not right to say that a court recommendation is a bit like the stage before a stage 1 decision. It's not. It's of a different quality, and that comes out very clearly when one reads Bouchereau in proper detail. And then paragraph 2.2 and paragraph 2.3 are two distinct powers to detain for the two different stages. One in 2 is where there's been a decision to make a deportation order, and paragraph 2.3 is where a deportation order is in force.
So 2.2 stage, on normal terminology, stage 1, 2.3 stage 2.
Yes.
Right? Yep.
And then the 2007 Act, which is at tab 8, page 78 of the same bundle. So what the legislation does, as I'm sure the court knows, or certainly does now know, is that it basically, it's this Act which in a sense grafts onto the 1971 Act. So it uses the 1971 Act as its fundamental underpinning, but it tells the Secretary of State what she needs to do. And I'll show the court in a moment the Alley case, which explains why Parliament decided that this step was necessary. So it involves the Secretary of State first asking, are you a foreign criminal? And you get that from 32.1 to 32.3. Now, I've just shown the court that stage 1 in the 1971 Act context is the Secretary of State deems your deportation to be conducive to the public good. We see here that 4 tells us if you have a foreign criminal, their deportation is conducive to the public good. So once the Secretary of State decides that somebody is a foreign criminal, she's essentially told that their deportation is conducive to the public good. Now, she still has to decide whether or not the person is a foreign criminal. Now, in fairness, in most cases, that's probably an easy decision, but not in all necessarily. The court should be aware, and we footnoted it, I think, in at least one of our skeletons, that there is an ongoing judicial review about whether a decision to make a deportation order is a decision at all. And the reason that the issue arises in that case is because the claimant in that case says, well, if you make a stage 1 decision, there's no decision making. You're basically doing what the legislation tells you, and therefore there is no decision to make a deportation order for the purposes of the legislation governing HDC, and the court saw that yesterday. Now, if that appellant wins, and the Secretary of State says it is a decision, actually, but it's not a decision that restricts residence rights, but if the claimant wins in that case, then that tends to strengthen the Secretary of State's position here, because if it's not a decision, certainly not one that would restrict residence rights. As I say, judgment awaited there, and the case was heard in May.
Sorry, I'm so sorry, Mrs. Barr, can I just interrupt? What does HDC stand for? I'm being
Home
really
detention curfew.
Oh, right, sorry.
Yes, so it's...
No, my fault for being stupid, thank you.
No, my fault for using abbreviations, because I also forgot what it was. It is, and happily remembered, the relevant provisions are included in the bundle in tab 7.
Yeah, thank you.
Who heard the JR case?
Mrs. Justice Foster, I believe, but we can provide the court the reference and so on. It's already been through an initial stage. There's already one judgment. It then came back. It concerns a very particular type of notice called a combined notice, which is no longer in use. But the claimant has argued that the court should decide more broadly if a stage 1 decision is a decision to make a deportation order. So what the Act then does is also force the Secretary of State's hand on the second stage, which is whether to make a deportation order, and the Secretary of State is told that she must make a deportation order in respect of a foreign criminal, but subject to section 33. And then section 33(7) tells you what happens if an exception applies.
I'm so sorry. Can I just understand
Yes.
what your submission is? So are you accepting that there is a stage 1 decision when section 32 applies, or not?
There is a decision, but it's not a decision that restricts residents' rights for reasons I'll come on to.
No. This is a slightly different question because
Yes.
this is just how it fits into your analytical scheme, which is deportation involves a stage 1 decision and a stage 2 decision. I just want to understand whether you accept that this falls within your analytical scheme or not. That's all.
It does, because the decision is whether or not the person is a foreign criminal, and therefore their deportation is deemed to be conducive
so
to
there
public
is-
good.
so
So
there
that's
is a
the
decision
decision.
there.
Yes, that's
Okay.
the decision.
But the decision is this person a foreign criminal?
Yes, and then the legislation tells you that their deportation is conducive to the public good, and then what happens, and I'll show the guidance as well, is that the Secretary of State asks for the information in order to get the information that she needs.
So under the 71 Act, the question is deportation conducive to the public good? And under this Act, the question is this person a foreign criminal?
Yes, and then therefore their deportation is conducive to the public good. But the Secretary of State is told that that's effectively the decision. The decision she has to make concerns whether or not they're a foreign criminal.
Where is the Secretary of State told that you have to make a decision?
Oh, section 32(4). The deportation of a foreign criminal is conducive to the public good. So, in a sense, there's no decision for her to make on that specifically.
Well, that's, I think, the lady's, I presume. Is it a decision?
Well, the Secretary of State has to decide whether the person's a foreign criminal, because if they're not a foreign criminal, then
Yes.
section 32(4) doesn't apply.
It's a
isn't
different
it?
sort of decision from.
But there is a decision involved because
Yes.
are they a British citizen, and have they been convicted?
Yes, well, that's certainly the point that the Secretary of State has made in the judicial review.
Yeah. No,
Perhaps not in those precise terms, but I'm not. I've been involved in the background, but I wasn't actually at the hearing or.
And it may be that it's a very easy decision to make in most
Right.
cases, but there may be odd cases where
Yes.
it's trickier.
Yes,
Yeah.
precisely so.
Okay, got that.
You're
And-
going to 33(7).
Yes, so 33(7), and I'll show the court a passage in the Supreme Court's decision in Ali, which says, well, this is all a bit odd, but we think this is what it means. So I won't try and summarise that. I'll let Lord Reed do it. But effectively, it's saying it doesn't prevent the making of a deportation order, but it ends up in a sort of neutral situation where it's neither assumed that it's conducive to the public good or that it's not conducive to the public good.
So in other words, where an exception applies, the Secretary of State is back in the position of having a discretion to decide whether or not it's conducive to
Yes.
the public good.
Yes, and it also, the example given by Lord Reed is that there can be a situation where presently somebody can't be removed because of something that's happening in their country of origin, but that may be temporary. Now, the reason that there's no exemption here in respect of post-transition period conduct is because the Secretary of State's case is, well, national legislation applies. Now, clearly, if we're wrong, and this court tells us that we're wrong, then either the Act will need to be amended or whatever the court says is the requirement of the Withdrawal Agreement will take effect via Section 7A. But the reason the reason that everything is structured as it is because the Secretary of State's understanding of the Withdrawal Agreement is that for post-transition period conduct, national legislation applies. So I was briefly just going to show the court the guidance as to how decisions are made. It's an older version of the guidance, but I believe this was the version before the upper tribunal in Vargova. So that is at tab 62 of the second bundle. Apologies for jumping. It's probably the best time to look at it. So this is what's called conducive deportation version 1, page 1508, tab 62. It's now up to version 5, but this is version 1. So there have been some changes, but not material for present purposes. So on page 1519, there's guidance as to how to make a stage 1 deportation decision. And that says, if a foreign national meets the threshold for deportation, you must consider making a stage 1 deportation decision and issuing a stage 1 decision letter setting out why deportation is conducive to the public good. Well, to come back to my lady's question, of course, once the Secretary of State decides that the person is a foreign criminal, it follows that deportation is conducive to the public good. So that's why, in a 2007 Act case, deportation is conducive to the public good, because they're a foreign criminal. And then, just between the hole punches, it said, in all other cases you must use the stage 1 decision letter when notifying the person of their liability to deportation on non-conducive grounds. And then it says, you must set out in the decision letter all disclosable information held by the Home Office about the person's circumstances at the time of the decision, including length of residence, immigration status and any dependents. Consideration of outstanding human rights claims should be deferred until after the person has had the opportunity to make further representations, so that all matters can be considered together. It's not very usual for the Secretary of State to have much information at this stage. She gets it by sending the stage 1 decision letter and sending out her form. And then the next paragraph says that the decision letter must inform the person they can make representations and that they should be asked to provide documentary evidence. And then stage 2, just briefly on page 1522, under consideration of representations, where a person has been served a stage 1 deportation decision, you must consider whether deportation remains appropriate in light of any new information or evidence provided. And then stage 2, on page 1523, by the bottom hole punch, stage 2, decision to make a deportation order. If no representations are received within the 20 working day deadline, you must consider whether to make a deportation order on the facts before you. So in other words, that happens at stage 2 even if somebody hasn't made representations. And then over the page, if the foreign national, this is 3 lines down, if the foreign national takes the opportunity to raise issues which they consider means that they should not be deported, these must be considered fully, and the stage 2 letter must set out any reasons for refusal. Now, pausing there, and before I come on to the decision letters in this case, I just want to deal with the new argument Mr. Cox has made.
Can I ask one question?
Oh, I'm so sorry, my lord.
Forgive me. Has there been any material, you say we're on to version 5, has there been any material, i.e. relevant amendment, material and or relevant amendment?
No, so I mean, we can certainly provide the court the current version. What it does do is get rid of what are called combined notices, and that's because the Secretary of State's accepted that they were not decisions from the AA litigation I mentioned. But overall, in terms of what I've just said, it's consistent. I'll ask those behind me to check, but I certainly did an initial check and it was materially the same in terms of, and that reflects my instructions as to how the decision making.
And there's nothing in version 5 which alludes either directly or implicitly to the withdrawal agreement.
It will. It absolutely will, because it's long guidance. But so both of them will allude to the withdrawal agreement in places, but there are lots of different.
So this is what's the date of this?
This one is November 2021.
So it's all post withdrawal.
Exactly.
Sorry, I hadn't appreciated.
Yes, it is.
Thank you. Is there any reference to Article 20 or 21?
Can I ask those behind me to check? there is a fair amount of guidance. I don't know if it's in this guidance or other guidance, but there's also guidance to decision makers about what to do if somebody could have pre and post transition period conduct. How do decision makers deal with that, for example? Because there can be a row about whether somebody's in the right regime, and we say that's fundamentally what this Regulation 6 appeal is designed to flush out, and that's it. Because on the Secretary of State's case, there's nothing else for it to flush out because there are no other rights. But I'll come on to that when I explain the appeal rights. So what I wanted to do briefly was just use the Molnar case to show how that is done. So this is in the Molnar core bundle. First of all, there's the stage 1 decision. It's at tab 22, page 166. So, page 168, under part 1, we get that this is the decision, and it's essentially the stage 1 decision that deportation is conducive to the public good. So it sets out the offence, and then it says you fall within the definition of foreign criminal because you're not a British or Irish citizen and you were convicted in the UK of an offence for which you received a sentence of at least 12 months. Under section 32(5), the Secretary of State must make a deportation order in respect of a foreign criminal unless one or more of the exceptions set out applies. You've not shown that any of the exceptions apply to you. In fairness, I accept it would be better if that said you've not yet shown that any of the exceptions apply to you, given that the purpose of this letter is to elicit the information. But it may be the case that in some cases the Secretary of State does have some information, although that, as I understand it, is relatively unusual. In the vast majority of cases, she will be saying you haven't shown that any of the exceptions apply and giving the person an opportunity to show that. What this means for you, if a deportation order is made against you, if. So it's saying a deportation order may be made, not that it will be made. And then it sets out, I'm sorry, above I should have said the deportation of a foreign criminal is conducive to the public good. That obviously comes from section 32(4). And then at the bottom of page 168, Secretary of State deems your deportation to be conducive to the public good, because she has to. And then we see
well, she says in under 2.5a
section
and
3,
and 32.5. Yes,
section
thank you.
3.5a. So that's the deeming.
Yes.
Yes. And then over the page under detention, that there is a detention power that comes directly from the legislation. This says you may now be detained, and then it makes clear what the Secretary of State is going to do. She's going to consider whether section 32(5) of that Act applies, and if it does apply, pending the making of a deportation order. So she's still considering the person's situation, and that is why the previous page says if a deportation order is made against you. And then there are various sections which invite the making of representations. See pages 170, 171, 172, 173, 174 to the end. So that's the stage 1 letter, and then the stage 2 letter is at page 143. Now, before we go to it, I realised I said I was about to address a point and then forgot. Mr. Cox's new point about, well...
I distracted you, I'm sorry.
Oh, no, I very easily distract myself. But Mr. Cox's point that, well, if you look at somebody who's got an appeal right under a different provision, the Secretary of State accepts that's a restriction decision, and so that must mean this is a restriction decision. Well, first, it's very late to raise that point. Had it been raised sooner, I could have turned up with an example of the sort of decision that is accepted to be a restriction in that type of case. The reality at a headline level is that if somebody is under the old regime, the process is different. They're not under the 2007 Act. It's not. It's not a helpful point to make. It's certainly not a helpful point to make at this late stage when the court doesn't have a decision in front of it. But
so when you say not under the 2007 Act, that's because an exception applies.
Yes,
so you're back to needing a real decision under the 1971 Act.
You're back to the whole bespoke
2016 regs.
Exactly.
Okay.
It's a whole bespoke regime which implements the directive of the 2016 regs. So it was obviously very beneficial protection for EU citizens. It made it harder to deport them. It's carried into effect for those who commit criminality before the end of the transition period. So that has a different process. But what I will say is that certainly from memory, and I'm having to do it from memory because the point wasn't raised, but that those decisions are not akin to a stage 1 decision. They're much more like a stage 2 decision, which is a substantive consideration of the person's circumstances. The things that are considered are different because the legal conditions are different. But in substance, there is a decision, and we say you simply can't compare the stage 1 decision here, which is saying, well, you are a foreign criminal, but can you tell us why we shouldn't deport you? So Mr. Cox's point is wrong, and in my submission it's too late to raise it, but if the court wants to see and wants further on that, we can put in a note.
We'll have a think about that. Yes?
I'm grateful. So with that in mind then, looking at the stage 2 decision, you can see that now there is a much more full consideration of Mr. Molnar's circumstances. So we see under Part 1 your representations have been considered. Reasons for the decision, we see much more about his immigration history. We see the conviction. We see that over the page the Secretary of State expressly says why she isn't considering his position under the old rule. So, third paragraph down on page 146, it's claimed on your behalf that the criteria set out in the same provisions of the EEA regs should be applied. But from 1st of January 2021, the UK's criminality and deportation thresholds apply. In other words, domestic legislation applies, so we're not going to apply the 2016 regs to you. Because the criminal behaviour which has made you liable to deportation took place on the 10th of March 2022. And then you get essentially a substantive consideration of the circumstances. And this is the Secretary of State now deciding that this person should be deported. And indeed she makes a deportation order, but she says you'll be given further notice of when you'll be removed.
Manu, I'm sorry, I just wanted to ask clarification. Is it the Secretary of State's case that this stage 2 decision is also then a decision to make a deportation order?
I think that's a submission rather than a question, but I'll answer it. Yes, but it's the second stage decision. It's the second stage decision which makes a deportation order and decides. It's not saying unlike stage 1, if a deportation order is made, it's saying, yes, we're going to make one. We've considered your representations. Now, I hesitate to address that question because decision to make a deportation order is used in a number of different legislative contexts, and it's a term of art. We're not addressing that here. That's not the question that arises in this appeal. The question that arises in this appeal are, here's the stage 1 decision that was made. Here's the stage 2 decision which was made. Does the stage 1 decision breach rights that are protected under the Withdrawal Agreement? Even if it's a restriction, does it breach rights under the Withdrawal Agreement? In our submission, no. How does it breach rights? It says.
You're coming on to develop all that.
Yes, I will, but that's it in a nutshell.
What do you say about this decision? What question arises about this decision?
What question? Or,
Yes, if you couch the question in terms of restriction rights. How would you say
well,
that applies here?
On these facts, there is a restriction because, I mean, not least because a deportation order is served. But I would accept that in the EU context, so the context of the 2016 regulations, the Secretary of State would make a substantive decision. So she'd ask for representations, then she would make a decision at stage 2. She wouldn't at that point make a deportation order, but she would accept in that context that the stage 2 decision was a restriction. Again, I'll ask those instructing me to check, but that's different from the stage 1 decision here.
So I mean, the distinction might be just expressed as a distinction between a decision that the person's liable to deportation. I mean, I'm not expressing this very accurately, and then making the deportation order once you've heard all their representations.
Yes, exactly. And in fact, it is, I mean, in terms of section 246, which deals with home detention curfew, and this is why one has to be careful about language, because decision to make a deportation order is not used necessarily consistently, but and perhaps it's worth just looking at it, because that's...
Sorry, just before we
Yes.
go there, on its face, stage 2 is described as a decision to refuse a human rights claim, but
Yes.
in essence, that's the decision. Can be described, you're saying, as in some sense, is a decision to make a deportation order, because the deportation order follows pretty much automatically from the refusal of the human rights claim on these facts. Is that right?
Yes, because at that point, the Secretary of State doesn't accept that she needs to make any kind of proportionality consideration.
No, I understand that.
So that's why that's all she considers. If the Secretary of State were wrong and we lose this case, then clearly she's going to need to do a proportionality consideration. Where and when is she going to do it? Here. Not at stage 1, because she doesn't have the information she needs to do it at stage 1.
So this is really a sort of stage 1.5, isn't it? In a sense, rather than stage 2. I thought stage 2 was making the order.
No, stage 2, yes, that's right, but the order's made on the same day. But what Mr. Cox is saying, I think... At the same time? The impression I'm getting is there's a sort of intermediate point. Actually, in this case, the deportation order is dated, and this was raised the 21st of September, page 155, and the decision is dated the 22nd. And we've explained that in our skeleton. And Mr. Cox has asked about it, and we've given some information, because what happens is that somebody decides that they're going to make the deportation order, makes it, and then writes up the reasons. It's explained in our skeleton, the decision-making process. But I think the reason that Mr. Cox stood up is because he is saying, well, there can't both be decisions to make deportation orders, the first one and the second one. That's his first point. And I think the answer to that is, well, there's a danger here of elevating substance over form. If the first letter is misnamed, because in fact the Secretary of State hasn't made a final decision, because she's saying, give me your representations, then what she has decided is that deportation is conducive to the public good, and in the legislative language, that is often referred to as a decision to make a deportation order. But we're in danger of fiddling around with semantics, which the ECJ is not interested in. It's interested in substance over form. What rights does that first decision
that's the
restrict?
question.
Quite.
So you could say there's a provisional decision, my word.
Yes.
Subject to representations.
Yes.
Then having had those representations, there's a decision to make the order, and then you make the order.
But it's not provisional in the sense that deportation is conducive to the public good.
No.
I mean,
Provisional was the wrong.
But
marker.
I think my Lady Justice Elisabeth Laing said, well, you're liable, aren't you? Because it's been decided that your deportation is conducive to the public good. And that is the way that the legislative language works in terms of the two.
But are you in practice? Is there this intermediate point where you make the decision?
Because this is the point
before you make the order.
So we've addressed this in our skeleton. In most 2007 Act cases, the stage 2 decision and the deportation order are made at the same time.
Right.
In a 2016 regs case, so an old pre-transition period conduct case, what you have is effectively a notice saying, can you tell us why we shouldn't deport you? Then you have a decision saying, well, we've decided that we're going to go ahead, so that you don't have that decision that deportation is conducive, because it's not how the EU regime works.
What is it that restricts rights? Is it the making the final decision to make the order, or the making of the order? What restricts rights of residents?
We would our primary case would be it's the making of a deportation order. I accept one could say that once the state has definitively decided that they're going to deport you, that could also be a restriction. And as I say, I accept, I think, and I'll check, that in pure EU cases with old transition period conduct, that is how it works, because you get your appeal before the Secretary of State makes the deportation order. But what I'm saying is this is fundamentally different. The question here is this stage 1 decision a restriction on rights? We say no, because what rights does it restrict? It just tells you that your deportation is conducive to the public good. And can you give us some more information?
And the Secretary of State couldn't lawfully make a deportation order without having considered whether one of the exceptions applies. So
Fine.
this is the stage at which the exception, particularly the human rights exception, is considered by the Secretary of State, and in this case, dismissed.
Yes.
I've got a vague recollection that years ago the Secretary of State used to give somebody a notice of his or her intention to make a deportation order.
Yes, so
And
that
that was a sort of clearer dividing line, because then the next stage was that the Secretary of State did or didn't make the deportation order.
yes, and I think
Why was that changed?
I think your ladyship is talking about the old EU procedure. That
Is that what that was?
Yes, that's
Yeah.
probably what you'll have seen. So
Yeah.
it hasn't in a sense been changed. That regime continues for anyone who benefits from it. What has changed is that for anyone who doesn't benefit from that regime, they fall under the 2007 Act.
I had a vague idea that used to happen in domestic, purely domestic cases. Oh, lots of people.
Oh
nodding.
well, yes, maybe that's.
But I don't know when that changed or why. Anyway.
What certainly hasn't changed since 1971 is this concept of one, is
no,
your
I understand
deportation conducive, and two, if it is, shall we make a deportation order? And all that the 2007 Act does is say to the Secretary of State, if the person's a foreign criminal, their deportation is conducive to the public good, and in that sense they are liable to be deported.
I think it might be quite helpful just to have a note about where this idea of a notice of intention to make an order came from and when it vanished. Please, if that's all right, because
Yes,
I think
of
that would
course.
help me. Thank you.
My lady, just for your note,
Yeah.
paragraph 44 of our skeleton, I think, gets into it a little, but I don't.
Oh, right.
I'm suggesting that's a substitution for the note that you.
No,
provided.
all right, thank you. Well, I'm sorry if I've overlooked that. Or maybe I've subliminally taken it in and that's what's
Prompted.
triggered the question.
Yeah.
Thank you.
What I would say is there is a lot of history and different processes.
No, I'm sure
but
there
Certainly is.
there certainly is. But if I bring it back to the issue in this case,
Yeah, yeah.
is this stage 1 decision a restriction on rights? And even if it is that a breach of the Withdrawal Agreement? And we say, but why?
We were coming on to that at the
Yes.
end.
So could I just show the court Ali, the case of Ali?
Yes.
Which
Mention that.
which is at tab 30 of the authority bundle,
Okay, so that's in volume 1.
volume 1.
So where does this come historically?
This
Is this a pre-Brexit?
it's nothing to do with Brexit because it's all about the 2007 Act.
Right.
It
It is-
probably is pre-Brexit.
well, the argument was
probably
pre-Brexit.
pre-vote,
The decision,
but it doesn't.
11 months later, 10
It's
months
not
later,
about
was
Brexit.
post the referendum.
Yes.
It doesn't matter.
Yes, but that's. I just wanted to invite the court to read paragraphs 10 12 and 14. Sorry that 10 and 12 aren't sidelined.
Could you just in a sentence tell us what this case is about?
So this is a case that went to the Supreme Court.
7 judges.
7 judges, and I think it's Lord Wilson who says this is very exciting because this is the first time that this court has had an opportunity to consider Article 8 and foreign criminals. He doesn't quite put it like that, in fairness, but that's broadly what it's about. That's why he's a judge and I'm not. He says, paragraph 65, this is an important day in the life of our court, for it's the first occasion upon which either we or our predecessors in the House of Lords have had occasion to address the interface between the power of the Secretary of State to deport and the latter's ability to resist deportation by reference to his rights under Article 8. It's a subject which generates strong views in our society. So that's what this case is about, and it's looking at what the 2007 Act has done and how it all fits together.
Yeah.
So, paragraphs
Very
10,
good,
12
thank you.
and 14.
12 and 14 this is Lord Reed, is it? Yeah.
This is Lord Reed. The main bit of 10 is essentially saying why it's sort of known as automatic deportation. And then paragraph 12 explains section 33(7).
Yeah.
And then paragraph 14 is important. We say expresses the public interest. So why did Parliament enact the 2007 Act? Now, this court may have come across Article 8 deportation cases in other cases. It's now quite well established that there are essentially 3 components of the public interest, albeit that the third, some doubt has been cast on the third. So the first is public protection. The second is deterrence. And the third is marking public concern. Now that is set out in a lot of authorities. The key one is HA Iraq. It's not in the bundle. We can hand it up. We've circulated it to the other parties.
Decision of this court or Supreme
It's Supreme Court. But that has been considered in a lot of cases, those particular 3 components of the public interest. It's coming. We've circulated this. I don't think it's controversial. The reason that I'm showing the court this is because, of course, we say, well, if the proportionality principle applies, what does the proportionality principle do at its heart? And I'm coming on to this. It balances the state's interests against the person's interests. But as soon as you say that national legislation applies, the state's interests are the interests in national legislation. They're not the interests of the EU project. And so the legitimate aim, if you're conducting a proportionality assessment, is this legitimate aim of public protection, deterrence and marking public concern.
So under the domestic scheme, the fact that you're an EU citizen and you've been here for ages and you or your parents exercising treaty rights is completely irrelevant.
Well, if it's post-transition period conduct, yes.
Yeah.
Because what the states have decided is that, well, up until the end of the transition period, everyone's residing in accordance with EU law. After the end of the transition period, EU law doesn't apply anymore. So if at that point you commit a crime, you're in the same boat as any other foreign national. Because what it's protecting is what's happened before the end of the transition period and not what you choose to do afterwards.
Yeah.
So that's why we say that if you take the public interest of the 2007 Act, the outcome is effectively binary, because if you want to respect that public interest, you don't make exceptions for reasons other than those Parliament decided exceptions should be made, and that is national legislation. Now, of course, if I'm wrong and somehow some bit of the directive comes back in, well, then, of course, that's what the Secretary of State will need to do. But we say that's not what the withdrawal agreement requires her to do. Yeah. So with that, can I come on to the second bit of my second topic, which is appeal rights? And can I start with section 11? Appeal rights, just for the court's note, are addressed in our skeleton at paragraphs 34 to 38.
Just, oh, that's in the main skeleton.
In the main skeleton, yeah, in the main skeleton. It's just there. So the other parties have relied on section 11, which is at tab 15. This section 11 of the 2020 Act, page 121.
Yeah.
Now, what this does is give the Secretary of State vires to introduce various appeal rights in various situations. Now, there are already lots of other appeal rights, but appeal rights under the 2016 regulations for pre-transition period conduct for those who benefit from that regime, and of course appeal rights under the 2002 Act. But this gives the Secretary of State vires to make new regulations in respect of a range of immigration decisions. The parties have made express reference to 11F and G. We say there's really nothing to be drawn from that, because what G says is that there can be appeal rights in respect of any decision made in connection with restricting the right of a relevant person, in connection with. So a stage 1 decision is certainly in connection with restricting the right of residence, but it doesn't itself restrict the right of residence.
Do you say this is a G or an F case?
So that refers to a decision to make a deportation order. So that the regs pick up the decision to make a deportation order. So that's an F case. But the point is that Parliament sees that because it refers in G to any other decision which is made in connection with restricting the right of residence. So that the class is decisions made in connection with restricting the right of residence.
So in other words, the regs could make provision about appeals against a deportation order, and the regs could also make give an appeal right in relation to what you call a stage 1 decision.
Yes. Yeah.
Well, but which do you rely on for the stage 1 decision?
But it's described in Reg 6, which I'm coming on to, as a decision to make a deportation
yes,
order.
so it's described in terms of paragraph F, isn't it?
Yes, it is. But my point is simply that what is that? Because G says any other decision made in connection with restricting the right of residence. So F are decisions in connection with restricting the right of residence, rather than...
I'm making a different point.
Oh, I'm so sorry, my lady.
When you get to the regulations,
yes,
the actual appeal right in Regulation 6 seems to be written in terms of F rather than G.
Yes, it is. I accept that. But it's now been, as the court will have seen, and I'll come on to the fact that the regs have been amended.
Yeah.
But decision to make a deportation order then is given a different definition, so that the appeal arises at a different stage, and that's the problem with terminology.
Well, can we take it in stages?
Yes.
We'll come to the regs in a minute. Can you just, for my benefit, elaborate or reiterate the point you're making about the words in connection with?
Yes. So supposing F said a dog and a cat, and then G said any other pet, you would assume that the draftsman thought that dogs and cats were pets, because any other tends to suggest that what's just gone before is the same. So in other words,
Deustum generis.
what's that? Yes, I'm not very good with that. I'm better with dogs and cats,
Well-
but I think that must be what I mean.
Well, the phrase "in connection with" appears in every single paragraph of 11.2, except for F, doesn't it?
Yes, but we say that nowhere can it be said that this legislation is saying that a decision to make a deportation order is a decision which restricts rights. And that's certainly, once you see the word G, in any event, it would be quite a surprising submission to make to the ECJ that because domestic legislation says something is X, then it must be X under EU law. It's simply the legislation. So, but in any event, there's nothing in this that helps the other side, because G is quite clear that those are decisions in connection with restricting the right of residence.
Yeah, so there's no assumption that that the relevant decisions are or have to be decisions to
No,
achieve the objective.
No.
They might be, or they might not be.
precisely. They might restrict, or they might just be a stage along
A
the way.
stage along the way. Yeah.
Just to deal with 11.7, a person, for the purposes of 2F and G, a person is a relevant person if Article 20 applies. Well, Article 20 is very broad. It applies to anyone who's within scope of the withdrawal agreement and who commits conduct before or after the end of the transition period. The reason that you get the B in 7 is because there will be people who are outside scope of the withdrawal agreement, and so to whom technically Article 20 does not apply, but who have leave under those particular rules. That's leave under the EU settlement scheme. So that's all that 7 is doing. It's bringing quite a lot of people within the scope of the virus to make appeal regs. So turning then to the regs,
But it includes people under 20, obviously under Article 21 and 22.
yes, it's people within Article 20, yes. But in fact, for those with pre-transition period conduct, their appeal rights arise in a different way, and it rather depends on whether or not they get a deportation order at the time they make an application under the EU settlement scheme, in which case they will have a right of appeal under Regulation 3. So that's on page 162. So that there's a case in the bundle that the tribunal doesn't that the court, a tribunal decision that this court doesn't need to look at, called Abdullah, and that is a case where all the appeals were, or some of the appeals were against decision to refuse leave to remain. And what happened is that at the same time as she refused leave to remain, the Secretary of State made a deportation decision and a deportation order. So those individuals then had the right of appeal under Regulation 3.
Okay, but we're all agreed, are we, that a decision to make under F, a decision to make a deportation order in relation to a person falling under Article 20 sub 2 is a citizen's rights immigration decision.
Yes, and C, Regulation 6.
We're coming on to the regulations,
Yes,
are we?
so page 163. The person to whom paragraph 2 applies may appeal against a decision made on or after exit date and make a deportation order under section 5.1 of the 1971 Act in respect of them. So that we accept captures the stage 1 decision. it isn't, it has to be because of 2, a person who's already got leave to enter or remain, or entry clearance, but then there's a carve out if the decision was taken under the old 2016 regulations regime, C6.3, because the appeal right arises under the 2016 regulations. So because necessarily as a result of leaving the EU there were various different cohorts of individuals, there is a fairly complex web of appeals provisions, and different people have different appeal rights. Some individuals can end up with 3 appeal rights. One under the 2016 regulations, one under the 2002 Act, and one under these regulations if they've got pre-transition period conduct. It just depends on the circumstances. But in any event, we accept this is the provision which covers this particular case. And then the grounds are set out in Regulation 8. There are essentially 2 grounds for the Regulation 6 appeal. And Mr. Hickman has already taken you to Regulation 8.2. So the decision has to breach any right which the appellant has by virtue of the withdrawal agreement. So it isn't good enough to say you've restricted my rights. You've got to say, and the Stage 1 decision breaches my rights under the withdrawal agreement.
Which regulation are you looking at?
8.2 on page 167.
Thank you.
And then there's a...
Just a moment. How are you for temperature?
Oh, fine.
Carry on. 8.2.
Regulation 8.2, and
Yeah.
then there's Regulation 8.3d, which is a second ground of appeal, where the decision is mentioned in Regulation 6. It's not in accordance with Section 3, 5 or 6 of the 1971 Act. Now that is a live issue and a tribunal appeal. What does that mean? How much scope does a tribunal have to say that the decision is not in accordance with Section 3.5?
Can we just look at 8 again? So, which part of 8 do you say we should have in mind?
8.2a is the right ground of appeal here. No ground of appeal was pursued under 8.3d, although it could have been.
8.2a.
Yes.
Yes.
So what I want to do now is explain why the Secretary of State set things up in this way and why it's changed. Now, just to come back, the Home Office understanding of the Withdrawal Agreement is that national legislation governs deportation, and so there's not really, if you've committed your crimes after the end of the transition period, you haven't really got any Withdrawal Agreement rights to assert. Or there's very little to be argued about. So if the Secretary of State had thought that the withdrawal agreement entitled a person to a proportionality consideration, she would not have introduced the appeal right at this stage, because it would have been before the person had made representations, and so it would have been before the Secretary of State had a chance to consider the proportionality principle, if it applies, and in however it applies, which still remains unclear, we submit. So that's how it wouldn't have been set up like this. Why was it set up like this? Essentially because the Secretary of State sees the one question that needs to be answered is this person in the right regime? And it might be thought at first blush, well, it's going to be obvious, isn't it, when the criminal conduct was committed? It isn't always, because there are cases where there is a blend of conduct, both before and after the end of the transition period, and indeed there have been cases where that has been raised in appeal. So from the Secretary of State's perspective, she wanted to make sure that somebody had the ability to say, I'm in the wrong regime. So the right of appeal isn't otiose. What she hasn't done is set the system up to allow somebody to argue that the deportation is disproportionate because she doesn't think that there isn't any right to say it's disproportionate. So that's why it's set up as it is. Essentially, if the person receives a letter saying, a stage 1 letter saying, well, section 32 says that your deportation is conducive to the public good, and we're going to make a deportation order unless one of the exception applies, the person can say, well, hold on a minute, Article 20 sub 1 says you have to apply Chapter 6 to me. So this is a breach of my rights under the withdrawal agreement. So that, and as I say, that has happened in practice. So that's what this appeal right was intended to do. So far as post-transition period criminality is concerned, and to pick up a question yesterday from my Lady Justice Falk, well, hasn't the Secretary of State breached the withdrawal agreement in not providing a discrete right of appeal at stage 2? On the Secretary of State's case, the withdrawal agreement is respected because what it says is for post-transition period criminality, national legislation applies, and so you get the protections of national law, including any appeal rights. The other parties accept, at least to some extent, that national legislation applies, and so in that sense proportionality would be an add-on. What they're saying is not the same as somebody would say if they're in the wrong regime, an Article 20 sub 1 case, well, you've got to apply all of Chapter 6. The parties accept, although they disagree as to how you get there, they do accept that national legislation applies at least to some extent, and so what the Secretary of State hasn't done on their case is not apply the wrong rules necessarily, she just hasn't done an extra thing. But we say whatever that extra thing is, it's not a breach of the withdrawal agreement not to do it at stage 1, because it can only sensibly be done at stage 2.
And I know it's not directly relevant, but the 2016 regime for those in the pre-implementation day period, how does that work in broad terms? Does it allow that sort of consideration before any decision is made?
Yes, it does. So they're told, in effect, you're liable to deportation. Then they make the representations, and then the Secretary of State goes through all the factors in the directive.
So no decision at all until that point.
No, it's effectively saying, in a sense, the Secretary of State, before the Secretary of State decides to send somebody a liability notice, she has to decide to send the liability notice. But what she says is, I'm considering deporting you, tell me why I shouldn't. So we say in substance there's not really any difference. It might be that different language is used, but in substance what she's saying is, well, I'm thinking of deporting you, what do you say about that? Now, it can't be contrary to EU law to say I'm thinking about deporting you, what do you say? Because as the court was seen in Article 21, there's a whole range of factors that the Secretary of State has to take into account. Well, she can't do that unless somebody tells her what their situation is. So it's not the case that, shush, you mustn't say anything about deportation, because you've got to. It's not real. You've got to say, well, look, I'm thinking of deporting you, why shouldn't I do it? But that's not a problem. It's not a restriction. Now, look, if we're wrong and the Secretary of State does have to do some additional consideration beyond an ECHR proportionality analysis at stage 2, then the Secretary of State is going to have to give some consideration to how persons who don't get the new 2025 regs that I'll come on to in a moment, how do they ventilate that their proportionality arguments in a withdrawal agreement appeal? Because we're saying, well, obviously that it doesn't make sense for that to happen at stage 1 and there's no restriction at stage 1. But as was pointed out yesterday, in this version of the regs, there isn't any withdrawal agreement right at stage 2. But the answer to that is twofold. The first is that we've accepted in our skeleton that if we are wrong and there is a right to an EU proportionality analysis, then that has to be done by virtue of Section 7A of the 2018 Act, because that's the provision that gives effect to the withdrawal agreement. And we therefore say, see our skeleton at paragraph 37, that that issue can be ventilated in an ECHR appeal, because if the Secretary of State didn't do that, she wouldn't be acting in accordance with domestic law. So there is a remedy. It may well be that something more would need to be done, but that isn't an issue for now. It's an issue of how the Secretary of State would give effect to any decision of this court that disagreed with her interpretation of the withdrawal agreement. What none of this does, however, is strengthen the appellant's case on the substantive issue which arises now. The Secretary of State has set things up as she has because she doesn't think there is any right to a proportionality consideration. If she's wrong, she'll have to go back and look at what she's done. Now, the reason, and Mr. Cox has very helpfully shown the court the new regulations.
Should we go back to it?
We can have a look. Yes, they're at tab 20.
How are you? Can I ask you this? You work for temperature. How's everybody for temperature? I'm very cold, so is it just me?
Well, I'm making submissions and hot under the collar, so I'm loving it. Long may it continue.
Well,
but I'm certainly not against the temperature being turned up.
Well, I'm just as long as everybody else is all right.
I'm not sure we can turn it up.
If I'm looking, I'm shivering. It's not necessarily a reflection on your submission. Not necessarily a reflection.
Necessarily. I have got cold hands, but the rest of me is very.
Well, okay. Where are we going with the? So remind the new regulations.
The new regulations are at tab 20.
Okay.
So what they do is define what a decision to make a deportation order is for these purposes, therefore with the effect that it's the second decision that at which the withdrawal agreement ground of appeal will arise.
So this does introduce a further stage, does it? Stage 1A? Or...
it doesn't introduce a further stage. It just means that the ability to argue withdrawal agreement grounds of appeal happens at stage 2.
Well, previously, a decision to make a deportation order, I think, was before representation.
Yes, exactly.
Now it's after representation.
Exactly.
So it's changed. It's not introduced new stage. It's shifted where stage 1 applied.
It shifted when the appeal right kicks in. When the ability to advance the...
Sorry, I'm really laughing because I'm trying to articulate it in your terms, stage 1. And
so stage 2. Stage 2. So it's...
No appeal at all at stage 1?
No.
So it shifted stage 2 back?
No,
stage 2.
Shifted the appeal to
So you still get the ability to appeal, but it happens... And indeed, one might think that the first tier tribunal decision in this case is a good advert for why the Secretary of State should have done that, because there's two discrete points. Why has the Secretary of State done this in the first place? Because she thinks that it's practically better for both appeals to happen at the same time. In other words, the human rights appeal and the withdrawal agreement appeal.
Which is what ended up happening in the Molnar case, isn't it?
They happened at the same time, yes, but that hasn't
Appeals.
always happened. So it really is just pragmatic, because it doesn't work very well if they're not heard at the same time. She hasn't done it because she thinks that there's a right to a proportionality consideration. She remains of the view that withdrawal agreement gives you a right to national legislation applying to you. That's it. So there's nothing more to argue about. All I'm saying is that if we're wrong about that, then it makes sense that the appeal right is at stage 2. That's not why this has been done. This has been done for pragmatic reasons. The person still gets their appeal right. So take Mr. Molnar. He couldn't have gone off to a tribunal at stage 1 and made any complaint, but he could go and do that once he gets the stage 2 decision. and nothing happens to him in terms of removal until that appeal has played out. So there isn't, in fact, there wasn't really ever very much to appeal about at stage 1 in terms of the withdrawal agreement, other than, as I said, ensuring that the person's in the right regime. But this is simply to make sure that both appeals happen at the same time, and in that sense, it mirrors what happens under the EU regime.
What prompted this change?
Practicalities. So because it was essentially these are new appeal rights. This is a complete change, and the Secretary of State has to see how it's going to work out in practice. And her experience of the way that appeals are playing out is it's actually better to have 2 appeals happening at the same time rather than, as happened in the Vargova case, for them to be split. That's all. And I don't know if the suggestion is that it's been done while this litigation was ongoing. It would have been quite wrong in my submission for the Secretary of State to thought this isn't working and for some reason not to have done it because she thought it might give her a litigation advantage in this appeal or not. As the case may be, it's neutral as regards the substantive question about whether there's a right to a proportionality assessment. It's just about when the appeal happens. And to be clear, although it doesn't arise here, there's absolutely nothing wrong in withdrawal agreement terms in it happening at stage 2. That's how it works in the EU regime. You get the appeal after the Secretary of State's gone through her thinking process. So that, unless the court's got any questions on appeal rights, I was about to say that's the techie stuff out of the way, but of course it's not. Because the whole thing is techie. But I'm going to move to Lumsden and the EU proportionality principle. So Lumsden is at tab 26. But the essential point I want to make in this third topic is this, that the proportionality principle is highly context specific, and Mr. Hickman accepts that. And the second point, which I'll be showing the court in due course, is that it underpins all of the protections in Chapter 6. It's not that one of those protections is about proportionality. All of them are, in effect, a manifestation of the proportionality principle. So what I'll be saying is it's not possible to fill it out, particular bits of Chapter 6, as being about proportionality. They all are. And the second point that I'll make, and I've already trailed it, is insofar as some sort of naked version of the proportionality principle applies, divorced from the directive, then it applies in a very new context where the aim is set by the 2007 Act, see Ali and H.A. Iraq. So the court, I think, was shown paragraph 23 of Lumsden, and the passage is sidelined. So just above F, any attempt to identify general principles risks conveying the impression that the court's approach is less nuanced and fact-sensitive than is actually the case. The way in which it's applied depends to a significant amount on the context.
Sorry, where are you reading?
Paragraph 23.
I've got it.
298.
298 around F.
Yeah.
But the Supreme Court repeats that on a number of occasions. At 32, it says again, as will be explained, the principle has been expressed and applied by the court in different ways in different contexts. In order for national judges to know how the principle should be applied in the cases before them, it's necessary for them to understand the nature and rationale of these differences and to identify the body of case law which is truly relevant. Now, one might think, pausing there, that if the contracting parties to the withdrawal agreement had intended the proportionality principle to apply, they might have told us how, for this very reason. They didn't, because they didn't intend it to apply. Then we get at paragraph 33, the classic exposition,
Yes.
which is the measure in question suitable or appropriate to achieve the objective pursued? And secondly, is the measure necessary to achieve that objective, or could it be attained by a less onerous method? Well, of course, it goes without saying then that you need to know what the objective pursued is. What's the objective pursued here? National legislation sets it. Under EU law, the imperatives were the imperatives of the Union as a whole, including things like rehabilitation and so on.
So what is the objective?
It's HARC, it's deterrence, public concern and public protection. And then again, paragraph 34 emphasises context specific. Paragraph 36 says you have to balance the private interest adversely affected by the measures against the public interest which the measures are intended to promote. And what does it do? It's a check on the exercise of public power. That's what the proportionality principle is. So it's basically constraining the ability of member states to do something. And again, what I say here is the public interest which the measures are intended to promote depends on the public interest promoted by the national legislation.
There's another way of putting it that you say Article 20.2 shows that national legislation was intended to be freed from EU constraints.
Yes.
And you've obviously got to deal with Article 21.
Yes, of course, yes. Yes, that's right, my lady.
So that you can't look at it through an EU lens.
No. Precisely so, because when one looks at Article 21 and 22 together, one says if you do your crimes then you get the benefit of Chapter 6, and the next one says if you do your crimes then national legislation applies. It's quite clear what that means. And then 54 and 55 of Lumsden point out again that it's necessary, see 54 3 lines down, it's necessary to identify the objective of the measure. And at 55 it's necessary to achieve is it suitable to achieve the legitimate aim in question. Now what we've got at the moment is a confusing mix differing between the parties of different bits of the directive coming back. But we say that doesn't work for reasons I'm about to come on to. If that's not the case, then what are we left with? If they're right and the proportionality principle applies, what does it do? Because this decision tells us, and we know, that the proportionality principle is essentially balancing one interest against another, and the interest is now the interest of national legislation. So that then brings me to my fourth topic.
Well, there is another interest, isn't there? That the whole point of this part of the withdrawal agreement is to allow those who have exercised their rights of free movement to preserve it.
Yes, but it isn't to allow them to go on committing crimes after the end of the transition period when the UK is left and benefit from the protection that they got before the end of the transition period.
I'm just thinking about what you're balancing here.
Well, that's in my submission. It's why it doesn't work to say that the proportionality principle applies. I mean, that's really my point. That hasn't. Given that the aims are the aims of national legislation, this is yet another reason why, if the EU legislature had intended that the proportionality principle should apply, we say it doesn't. It says Chapter 6 doesn't apply, so that's gone. We say, does the proportionality principle then come in as a separate thing? Well, if it does, it can't really do anything because it said that national legislation applies. And surely we submit, if that is what had been intended, the withdrawal agreement would say so, because otherwise it leaves everybody including the other parties in this case, in a bit of a mess, trying to say what applies and what doesn't. And the fact that it doesn't do that and simply says national legislation, we say it is very clear. So moving on then to EU law protection against deportation, it's addressed in our skeleton at paragraphs 40 to 55, just for the court to know.
In the main skeleton. In the main skeleton.
In the main skeleton,
Yes.
yes. So I wanted to start with the directive, which is at tab 22. Can I start with the recitals, which begin on page 204? So what recitals 1 to 3 show is that the provisions in the directive are very much based on the concept of union citizenship. But that has now gone. UK nationals are no longer EU citizens, self-evidently, and EU nationals can't assert union citizenship rights as against the UK. That's gone as a result of the UK leaving the EU. Could I then invite the court, please, to read recitals 22 to 25, which are on pages 210 to 211. So starting with recital 22, I've been accused of inventing a distinction between, I think we've called it substantive and procedural safeguards. I haven't. I've got it from recital 22. What recital 22 says is, in order to ensure a tighter definition of the circumstances and procedural safeguards. And then what recital 23 and 24 do is summarise the substantive protections, and I'm going to call that a different thing in a moment in case it helps with the concept. But recitals 23 and 24 summarise the substantive protections, and then recital 25 says procedural safeguards should also be specified in detail in order to ensure a high level of protection, as well as to uphold the principle that any action taken by the authorities must be properly justified. So the directive draws a distinction. Notice here no reference to a distinction between grounds and safeguards. It's something that's been invented. But there is a distinction drawn in the way that the protections are analysed. Now, what's the right way of analysing them? We'd say this is one way of doing it. We've called it substance of procedure. Another way of doing it would be to say the constraints on the member state's ability to restrict residents' rights, and then, on the other hand, the procedural safeguards which ensure that the state has observed those constraints. The other point...
I'm so sorry to interrupt, but just sort of pursuing that thought. The reference to proportionality is in recital 23.
Yes.
And it seems to be conceived as a different thing from procedural safeguards.
Yes.
Yeah,
we
sorry,
say
maybe that's a statement of the obvious.
Yes, and exactly. And to answer a question that came up yesterday, of course there is a procedural safeguard related to proportionality. It's testing the member state's decision on proportionality. But And your ladyship is quite right in drawing attention to recital 23, and I was about to come back to it, because what that very much shows is that proportionality is the font from which all the subsequent protections flow, because what it says is this: expulsion can seriously harm persons who've availed themselves of the rights and freedoms under the treaty and become generally integrated. The scope for such measures should therefore be limited in accordance with the principle of proportionality, to take account of the degree of integration, the length of their residence, their age, state of health, family and economic situation, and then accordingly, so following on and as a specification of also of the, as an implementation, of the proportionality principle, the greater the degree of integration, the greater the degree of protection, and that then is the inspiration for the imperative grounds. So
Yeah.
what you see in Article 28, all of Article 28, is the proportionality principle in action. The legislature deciding, well, we are going to, in the spirit of proportionality, we are going to tell member states that if somebody's got a right of permanent residence, this threshold have to be met. If they've got 10 years residence, which is the imperative grounds protection, then this threshold has to be met, and that is all, we say, flowing from the proportionality principle. It's the legislature deciding what is and isn't proportionate. So moving on through the directive, Article 15, it isn't applicable under the directive in cases of criminality, but just to note that it says that it envisages that procedures may apply on grounds other than public policy, public security or public health. And we know that includes the ground of removing someone because they no longer have a right to reside. And I'll come back to Centulia. And then what you then get are the substantive and procedural protections in Chapter 6. That's on page 232. So Article 27.1, this is essentially the gateway. Member states may restrict the freedom of movement and residence of union citizens, blah, blah, on grounds of public policy, public security or public health. So that's the gateway. And then you go down the path of doing that. The directive tells you all the things you can and can't do. Now, the restriction, there has to be a restriction. We've referenced in our skeleton a case called ASBL at paragraph 46. The court has it at tab 57. We don't need to turn it up, but it basically says things like restriction can also include something like house arrest. And there are also examples there are some Bulgarian cases where the Bulgarian authorities essentially banned people from leaving Bulgaria because they owed money. That's also a restriction, unsurprisingly. But what we say here is that the stage 1 decision is not a restriction. Mr. Hickman said a legal right is an intangible thing. It doesn't need a physical constraint. But one has to be careful here, because if one is talking about suggesting that there's any qualification on the right to reside, the right to reside is always subject to some constraints because it's inherently conditional. It's also set out in some very old EU cases that there is a difference between EU nationals and host state nationals, because one group is subject to deportation and the other is not. So at which stage do you say a restriction applies? We say that EU law looks to the substance and not the form. And so if you write to someone saying, and I don't want to spend too much time on this because I've already made the point, but if you write to someone and say, our domestic legislation says your deportation is conducive to the public good, but if there's an exception, we're not going to deport you, then that is not a restriction at that stage. And the second point that I've made is, at some point, the Secretary of State is going to have to ask them to make representations, even under the EU scheme. So if you just flick over while we're here to Article 28.1, the EU scheme must absolutely envisage some sort of letter warning the person that they may be deported, because otherwise the Secretary of State couldn't get the information in Article 28.1. What she can't do is take the expulsion decision, and we say that that doesn't happen until stage 2. But even if we're wrong and it's a restriction, it's still not...
I'm so sorry, Mel, can I just clarify? Is it being said that stage 1 is not a decision to make an expulsion decision? Not a decision to make a deportation order?
I'm saying it's not a restriction.
But you're saying it's not a decision to make a deportation order?
It is a decision to make a deportation order under the method.
I think it's best, Mr. Cox, to
Sorry.
allow Ms. Smythe to develop this
Okay.
complicated argument and respond in due course.
Yes, I'm very grateful, my lord. I've made my point about why it's not a restriction at stage 1. It's just take a step back, look at the letter saying, under our domestic scheme, you're a foreign criminal. Make some representations. We'll consider them. But it's conditional. It says if. So it's not a restriction at that stage. But in any event, even if it is a restriction, that doesn't answer the question of whether there's a breach of the withdrawal agreement. Why is it a breach of the withdrawal agreement to say to somebody what the Secretary of State said in the stage 1 letter? Nothing's going to happen to them. I accept that stage 2 is capable of being a restriction with or without a deportation order, but that's not what we're arguing about. We're arguing about stage 1.
Just to remind me, do they become liable to detention when the stage 1?
Well, they're already liable
Decisions
to
made.
detention under the 2007 Act.
Right.
If they are, there's 2 points. So there's the case of, I think it's Nurasley, which basically says the Hardy or Singh principles effectively do the same as the EU law protections in terms of detention.
Sorry, you'll have to translate that.
Yes, so that what we would say, let's start with it at this level. If there's a decision to detain, that's a separate decision from the stage 1 decision.
So that would be a restriction.
Yes, to detain somebody, I accept, would be a restriction. There's a case called, I think it's Nurasley, and we have it in the bundle, which basically says the Hardy or Singh principles effectively comply with EU law. I think it might have been Nurasley in the Court of Appeal rather than the Supreme Court, but in any event, that's how it works.
So you would accept that the decision to detain would be a restriction,
Yes.
but you wouldn't accept that the liability to detention is a restriction?
No.
Right.
What I would say, I mean, because otherwise that means the Act is itself a restriction in granting a detention power. But one would then say, well, even if so there will be a discrete decision to detain. It doesn't happen automatically.
No,
So-
no, I
Yes,
understand that.
so that's my point. That
Yes.
that would be a restriction, but it doesn't make the stage 1 decision a restriction.
No, all right.
Particularly when the power in fact comes from legislation. But the point is more that there would be a discrete decision to detain.
Yeah, got it.
Similarly, we've dealt with home detention curfew in the skeleton. We say this isn't a case about whether the exercise of the detention power or the availability of home detention curfew breach the withdrawal agreement. It's not what it's about. In fact, the operative restriction we say in the case of home detention curfew is the original sentence of imprisonment. What home detention curfew does effectively is let somebody out a bit early, and the arguments about that have essentially been discrimination arguments. It's not right that British nationals can get out early and I can't, or other categories. But again, we say that's not really the issue here. The issue here is the stage 1 decision restriction, and even if it is, does it breach the withdrawal agreement, and why? How does it breach the person's rights to get that stage 1 decision? We say it doesn't. So Article 27.1, we've seen if you want to restrict on public policy grounds, you need to do all the things that follow. And then we say, for everything that follows, all of these requirements in the directive, there is simply no principal basis for drawing a distinction between grounds and safeguards.
Sorry, you're looking at 28.
Sorry, yes, I flicked over to 28. Could we turn back to 27?
Yeah.
So we're doing 27 separately
Yes,
from
I shouldn't have
28?
jumped. I shouldn't. Yes, we are. I shouldn't have jumped to 27.
So we're now looking at the
27.
distinction that Mr. Hickman sought to.
Yes, well,
I think you call it the filleting.
so it does. We don't. We think it's an attempt to give some sort of meaning to Article 22 without it meaning what it says, but it just doesn't work. Nowhere in this directive or in the case law of the ECJ will you find any reference to a distinction between grounds and safeguards. What you find is what I showed the court in the recitals. Similarly, we submit no principal basis has been advanced for being able to decide whether something is a ground or a safeguard.
I know you're coming on to the withdrawal agreement at the end. When the withdrawal agreement talks of, in 22, of the safeguards, I hope you don't mind my just interposing.
No, not at all.
Is it your case that is, what is your case? What is it referring to? Is it just referring to the procedural safeguards, which you have distinguished by reference to the recitals?
Yes. Because otherwise, if it brings back, and this has been argued by the parties below, if it brings back all, because look, let's face it, anything in Chapter 6 can be described as a safeguard. I'm safeguarded against deportation because you can't base it exclusively on my personal conduct. I'm safeguarded from deportation because my personal conduct has to be a genuine, present and sufficiently serious threat. I'm safeguarded from deportation because you've got to consider my circumstances. I'm safeguarded because I have a right of permanent residence and you need to show serious grounds. So it's all a safeguard in that sense. But if Article 21 were to bring back all the safeguards in Chapter 6, then it makes Article 20 sub 2 completely pointless. And if what one is doing is applying a common sense approach here and looking at realistically what the parties intended, in my submission it's quite clear what they intended by virtue of Article 22. So that's the answer. It means procedural, because otherwise it basically robs Article 22
Effectively,
of any meaning.
it's Article 15, headed procedural safeguards.
Yes, and Article
30 and 31.
31, and then your Lordship may say, well, hold on, doesn't Article 31.3 reapply Article 28?
Yes.
And
right.
the answer to that is, well, if that's right, it brings back in the serious grounds protection and the imperative grounds protection.
Sorry, can you just bear with me and
Of
explain
course.
what you mean by the terminology there, imperative grounds?
Yes. So
You may be coming on to that.
yes. So it's
I rather rushed you ahead
28.
then, forgive me.
yes.
Yeah.
So that's in Article 28. So shall I
Okay.
explain
But
it when
well,
we
you're
get-
going to Article 27. I think
Yes, so I'm
you're on.
still in Article 27,
I'm sorry.
but I promise I'm coming to. I will be coming to that. It is very strange language. It's a term of art. It doesn't,
Yeah.
to me anyway. It may just be my brain.
What's the term?
Serious grounds and imperative
Okay,
grounds.
fine.
But can I just say, in relation to 27.2, we say that all of those four limbs of Article 27.2, and I'm using Mr. Hickman's numbering, can't be separated out. They're all really doing the same thing.
Well, in the end, he said, I think he said 27.2 is safeguards. First paragraph, safeguards. Second paragraph, grounds. That's where he
Yes. So
ended up.
and we say that just doesn't make sense. It's not right. It doesn't. They're all requiring the measure to be based exclusively on the personal conduct, and they're also saying that the conduct of the individual has to be a genuine, present and sufficiently serious threat. So if, for example, I have 15 years ago stolen a Mars bar, it's unlikely that my personal conduct is going to represent a genuine, present and sufficiently serious threat. I could 15 years ago have murdered somebody, but it may be that I am completely now reformed. In those circumstances, you can't look at the murder, you've got to look at whether I represent a genuine, present and sufficiently serious threat. So you can't, the requirements in the first and second subparagraph are effectively doing the same thing. I should say that that's subject to what's often called the Bouchereau principle, which means in some exceptional cases you can look at conduct alone, but it is an exceptional principle. And but we say you really can't sensibly split out bits of Article 27.2. And as I've said, we agree that Article 27 covers more than expulsion. It also covers the examples I gave of house arrest and forbidding somebody to leave. But we say there is no principle basis for Mr. Hickman's submissions, and they're not supported by the language of the directive or by the recitals or by any case law. Then Article 28. So it's got three limbs. So the first is protection against expulsion.
Well, it's all about expulsion.
It's all about
expulsion.
Yes, it's
expulsion decisions.
exactly. So what I should say first of all is that, as we saw from the recital, these requirements in Article 27 flow from the proportionality principle. Because
So you're now on 28.
yes, I'm so sorry. I realised I hadn't made a point on Article 27.
Yeah.
So the point on Article 27 is it flows from the proportionality principle that the personal conduct has to be a genuine, present and sufficiently serious threat.
'28.
28. So Article 28.1,
Are these safeguards?
it depends what one means by safeguards. As I said earlier, well, if one means safeguard, any safeguard, well, yes, but that means then that Article 21 completely undermines Article 22. I'm not going to use
Well,
Mr. Hickman's
So,
distinction.
taking this as your case is that the word safeguards in 21 of the Withdrawal Agreement does not include the
Yes, so if you're
the
yes,
provisions of 28 in
quite.
the
So
directive.
yes, so the question is, are they safeguards? What does one mean by safeguards? If one means Mr. Hickman's meaning of safeguard, I'm afraid I don't fully understand it, because it's unprincipled in my submission, and for the reasons I've given, doesn't find any base in this directive. So
On
I
your
can't answer
analysis,
that question.
These are Article 28 is about a stage 2 decision, isn't it?
Yes, on
On your
my analysis, these are substantive. These are constraints on the ability of the member state to deport in principle. The recitals called them the circumstances in which a member state can deport. What they are not is safeguards within Article 21. They are the protections that apply to those falling within Article 20 sub 1.
So they are safeguards on one analysis, but they're not safeguards within the meaning of Article 21.
They're not procedural safeguards.
Well, the word procedural doesn't appear in Article 20.
No, but my point is that that's clearly what it means, because otherwise all of Chapter 6, as I said earlier, all of Chapter 6 can be said to be safeguards. So if that's right, Article 21 completely negates Article 20 sub 2.
Well, that's going to be your ultimate argument when we get to the withdrawal agreement.
It's one of them, yes. So, my Lady Justice, is it Falk or Falk?
It's Falk.
Falk,
Falk.
apologies, Falk. Asked me, well, what?
Carry on. Laing.
Laing, I'm so sorry. Please call me Smith as punishment.
Baker's quite a straightforward Baker. You won't have to. Yeah. Carry on.
So, my Lady Justice Falk asked me, well, what is this? How it works is that if somebody's got what's called a right of permanent residence, the member state has to show serious grounds of public
Yes.
policy or
Yeah.
public security. And if they've got what's often called the 10-year right, the state has to show imperative grounds of public security.
Oh, I see. It's just following the labelling and the.
It is.
Yeah.
So, for example, what might be imperative grounds of public security? There's a case, if there's time, I'll show the court, called Sakaridis, which says, well, doing various drug-related things
Yes.
can be imperative grounds of public
Okay.
security.
But it's clearly an increasing.
Exactly.
Yes.
Yes,
Tiers, I think it's
precisely.
called.
And we say, effectively,
And that
it's...
reflects recital 20. I can't remember which one.
24.
23 or 24.
Yeah, and recital 23. So you get the general thing about you have to consider length of residence, but the legislature has in effect decided that unless there are serious grounds of public policy or public security, you can't deport somebody who's got a right of permanent residence. So again, that is a manifestation of the proportionality principle. So far as Article 28(1) concerns, we say it's obviously implicit in that the member state is entitled to say, we're thinking of deporting you, give us some information. And there isn't anything wrong with saying under our domestic legislation, deportation is conducive to the public good. Tell us about that. Tell us why you shouldn't be deported. Not that Article 28 applies, but even under EU law. And then Article 30 is the notification.
So just before we go on, because
Yes.
28(1) is very heavily relied on
Yes.
against you.
It is, but
And what do you say specifically about that?
I think the point, it's been suggested that Article 28(1) is the proportionality principle. So the first point I make is that's wrong. All of these protections are manifestations of the proportionality principle. And if the court may recall that Article 31(3) of the directive, and we'll look at it shortly, refers to Article 28.
It does.
All of Article 28. So if Article 28(1) comes back, why not Article 28(2) and Article 28(3)?
Well, because, are we going to that now?
Well, I think Mr. Hickman's case is, it's got the word grounds in it.
Well, if you look at 31(3), it says the redress procedures shall ensure the decision is not disproportionate, particularly in view of the requirements laid down in Article 28. So what are the requirements? I'm thinking aloud.
All three.
You say it's not just the considerations to be taken into account in 28(1), but the requirement for serious
Yes.
or imperative grounds in 28(2) or 28(3).
Yes, and it doesn't. It's quite clear what it means, and that is tested on appeal. There have been innumerable appeals where the tribunals have considered whether the serious grounds and imperative grounds thresholds are met. So, and I think Mr. Hickman's answer is, well, no, you don't have to worry about Article 28(2) and 3 because those are grounds. But apart from the fact that they use the word grounds in them, the reality is that they are substantive protections, circumstances, as we see from the recitals, when a member state can deport someone.
Well, couldn't they be safeguards, leaving aside what Mr. Hickman said? Could they not be safeguards in that it requires a higher level of concern about public policy or public security?
I think your lordship has my point that all of this is safeguards. It's not a procedural safeguard. It's all safeguards. An individual can say Article 27 safeguards me, Article 28 safeguards. They're all safeguards in that sense, but it's not, in my submission, what Article 21 is preserving.
We'll come back
I
to
mean, another way of putting this is that what Article 28(2) and 3 do is they're specific examples of a more general principle in 28(1, then prescriptive.
Precisely.
So you might look at 28.1, that's a sort of more general principle, but then the rights, you've got even more entrenched rights as you get longer residence.
Precisely, my lady, and that's why conceptually Article 28.2 and 3 can't be distinguished from Article 28.1, and I've shown the recitals. The recitals don't distinguish between them conceptually.
Yeah. Okay, thank you. That's 28.
Yes, that's 28. Article 30 is about notifications.
Yeah.
This is requiring the state to set out its reasons. It's not a constraint on the circumstances in which a member state can deport, but it's requiring them to explain their reasons. And the reason that the point we draw on in Article 33 is that it refers to the time allowed for the person to leave the territory. So we say that's envisaging being required to leave, or certainly something closer to it than the stage 1 decision in this case. The reason that the words "where applicable" appear in Article 30 sub 3 is because a restriction decision doesn't have to be a decision, doesn't have to be a telling somebody to leave. It can be putting them under house arrest or detaining them or preventing them from leaving. So that we say is what the directive in recital 25 sees as a procedural safeguard, and then Article 31 is called procedural safeguards, and we say that is exactly what it does. It's the means by which authorities, including the courts, check that the state has acted in accordance with the substantive constraints on it. So has it, or is the decision based exclusively on the personal conduct? Is the personal conduct a genuine, present and sufficiently serious threat? What about the factors in Article 28.1? And insofar as the proportionality principle is engaged, is the decision proportionate? But in that sense, what Article 31 is doing is saying that, in other words, what you get is a match. To get the procedural protection, you have to have the right in the first place. So if you've got a right to a proportionality consideration, then it's protected on appeal. What you don't have is a situation where the decision maker isn't required to apply proportionality, but the tribunal is. So the safeguard is, if you have a right, has that right been respected? So that's why there's a specific reference to proportionality in Article 31.3.
Because it assumes that this is a decision under the regime in the CRD, and therefore proportionality will be one aspect of the constraints on the member states' ability to deport. But Article 31 is not itself a source
Exactly.
of a right to have it considered by
Precisely.
a proportionality test. Yeah.
Yes, because otherwise that would be the.
Because in other words, the premise of Article 31 is the rest of the machinery.
Precisely. And otherwise that would mean the procedural tail was wagging the circumstance dog. I'm using circumstances because that's what the recitals use. I'm just touching on Article 35, abuse of rights. That is a classic concept of EU law. It's defined in case law. So I would accept if the withdrawal agreement referred to abuse, that is genuinely a concept of EU law, and it would bring in the case law on abuse, and there is a lot. But we say grounds isn't a concept. So what we've done in paragraph 57 of our skeleton is attempt to break down the different functions which the proportionality principle performs under the Chapter 6 regime. So the court has that in writing, but fundamentally, for the reasons I've just given, we say it informs and underpins all of the constraints on member states in Articles 27 and 28. I was going to go to some cases at that point, and I start with Bouchereau.
Yeah.
It is in tab 46, which is the second bundle. Before we look at Bouchereau, can I make a general point? Which is this, that as this court will know, what the CJNU does is answer a question or questions which have been referred
Yes.
on the facts of a particular case. So you have to read its answer in context, and also you can't read the decision selectively. We say this decision is being read selectively. So I just want the court, if I may, to look at the Advocate General for some important context here. So if the court could turn, the writing's bigger, at the top, 736 and 737 of the report, it's 1024 of the bundle.
Yes.
What the court has got here is a comparison between a decision under section 3.5 of the 1971 Act and then a decision where there's a court recommendation. And what's pointed out is that under the system of appeals, you can't make a deportation order until the appeal has been exhausted. And then what the Advocate General points out is that if you get a court recommended deportation, the appeal system is excluded. So it's not right to say, well, actually, it's just a recommendation and it's all much better than getting a stage 1 decision. It's actually, that's not the case at all. And if one reads this analysis of difference between the two types of decision, it's quite clear what the court is looking at. And I've shown the court in the 1971 Act that where you have a court recommendation, the person shall be detained. It's not even may, subject to a couple of exceptions. Now, what then the Met Police say on page 1026 is that the court recommendation is just a notification to the Secretary of State, CD, so the Met Police say, well, actually, this court recommendation is just a notification, and then the government at E say, well, actually, no, that goes too far. The government say a recommendation for deportation made by a court is not a mere notification, it has legal consequences. Not only does it render the alien concerned to make a not only does it render the alien concerned liable to be detained, it empowers the Secretary of State to make a deportation order without the need for the decision to that effect to be subjected to an appeal. And then that at H, the government accepts that a court is required to apply the directive. So with these submissions, the UK couples a concession that nonetheless it wouldn't be open to a court to ignore the provisions in the directive, that such a court must have regard to those provisions. So the UK is accepting that the court is bound by the provisions in the directive, and one might then think, well, it doesn't really matter semantically whether or not this is a measure. The UK government is accepting that a court needs to apply it, and then one can see that from what the Advocate General says at 739. The attitude of the UK government's a bit puzzling. What's the purpose of saying in one breath that a judicial decision isn't a measure to which the directive applies, and in the next breath saying that the courts of the member states are bound by it? And then at 7:40, at 1028, what the Advocate General says at the bottom there is the word measure isn't one of precise import. This is just above G. Its interpretation requires a consideration of the context in which it's found. Plainly, a recommendation by an official to his minister, wouldn't constitute a measure, but it wouldn't have legal effect. But one cannot assimilate to such a recommendation of the kind here in question, and so on. And then goes on to describe the consequences. So he says on this, the semantic aspect of the case. So what he's really saying is, well, let's not row about whether or not it's a measure. The government's basically saying that the UK court needs to comply with it, and what really matters is the substance and not the form. And then if one looks at the judgment, the court's only been shown an isolated passage in the judgment. Starting at at page 1042 or 754 of the report, at 754, the court records what we've seen, the UK acceptance that a national court is in fact bound to apply the provisions. And then, could I invite the court to read? Essentially, my submission is going to be that the entirety of the passage from 16 to 24 needs to be read, rather than the isolated bit that Mr. Hickman has invited the court to read, to understand why the court reached the decision it did on the facts of this case.
16 to 24.
16 to 24.
Right. We'll read that now. You sit down. Yes.
So I should have said, apologies, at paragraph 11, the court does the same as the Advocate General and records what it describes, or certainly what the Advocate General described, I think, as the strange or puzzling submission of the government, that the UK declares that paragraphs 1 and 2 are directly applicable and confer rights on nationals, but that they're not a measure. So very different from the circumstances in this case, because the government is accepting that these principles, that those provisions apply. And then at paragraph 16 to 17 is the key reasoning. And then it adds, of course, at 19 that the UK accepts that the courts are bound by the relevant provisions when they're making a recommendation. And we say, purposes of 21, a measure, and this was wording used in a different legislative instrument, any action which affects the rights of persons, we say the stage 1 decision here did not affect rights in that sense. So when we say in our skeleton there's a world of difference between this case and the present one, we mean it because this is a case where the UK accepted that when a court was making a recommendation for deportation, it was required to consider the genuine, present and sufficiently serious threat type question. And that's not really surprising. So,
well, in the context of no other appeal right.
And no other appeal right, yes.
So this is the last chance.
This is the last chance. So it's a very different context, and we submit it really doesn't support the arguments advanced here in support of this stage 1 decision being a restriction. What's said here is, it's said that this decision stands as authority for the proposition that anything on the way to making a deportation decision is in effect a restriction. Well, that in my submission is absolutely not what it decides and is incorrect in principle.
Thank you. Now, how are we doing?
I wanted to briefly just show the court 3 cases, just so that the court gets a flavour of how the ECJ has actually applied the directive's protection. The first one is just to be aware of because it predates the directive, and that's Orphanopolis at tab 49. We're staying in the same bundle.
Okay. Well, shall we deal with this one before lunch?
Yes, because we can take it very quickly.
Orphanopolis.
Orphanopolis.
So that's pre-directive.
Pre-directive, yes. So this is the court grappling with how to apply constraints on a member state making a decision on public policy grounds before the directive under the old legislation. So just for the court's note, the court will see at paragraph 66 to 68
Of the judgment.
of the judgment at 1134.
66 to 68.
The old version of what's now Article 27.
Okay. Yep.
So that's effectively a statement in the case law of what appears at, or now appears in Article 27. The other passage is sidelined, and that's 95 to 100, and that is an example of the court essentially spelling out pre-directive how the protections should apply. And what the court will see at paragraph 95 is it essentially begins its analysis by effectively stating the proportionality principle.
Yes.
It also addresses fundamental rights at 97.
Yeah.
And at paragraph 98 addresses Article 8 of the ECHR. So if we said in our skeleton that's part of proportionality, we say if it survives, that's the only bit that survives. That's the only bit that is capable of being consistent with Article 20 sub 2.
And do we look to need to look at the answer to the first question, sidelined paragraph 100?
100 is the dispositif, yes. So
Yes.
the second indent.
And you say that that is effectively the proportionality principle in action, do you?
Yes, so what it illustrates is that the proportionality principle lies at the heart of the protections, as I said. It's very interwoven with all of the protections.
Yeah.
And it also involves consideration of private and family life. What all of these cases show is that the protections are very interwoven, and what they certainly don't show is that there is some proper distinction to be drawn between grounds and safeguards. It's just not here because it doesn't exist.
Right. So you're now moving on to your second case. You're going to show us 3 cases.
I was going to.
Shall we rise now? Would that be suitable? How are you doing?
Okay.
I think you're doing quite well in terms of time. That's
I
what I
hope
mean.
so.
I mean, it doesn't feels to me as though we're on track.
Yes, I think we are.
Good. Thank you very much. I look forward to seeing you at 2 o'clock.